FBI agents searched the Virginia home of a Washington Post journalist yesterday after obtaining a search warrant. Reporter Hannah Natanson, who covers the federal government, was home during the search. Agents took a phone, a Garmin watch, a work laptop, and a personal laptop. The Post reports the action as part of an investigation into Aurelio Perez Lugones, a government contractor with a top security clearance. According to an FBI affidavit, he's suspected of illegally accessing and taking home classified documents. An official says he was messaging Natanson when he was arrested, and classified content appeared in their chat. Joining us now, media reporter for the New York Times, Ben Mullen. He is co-author of a new piece for the Times detailing this case. Ben, it's good to have you on. What more can you tell us about what is happening here? Federal agents searching a reporter's home is being described as highly, highly unusual, yet legal. What do you make of it, and what more can you tell us?
Well, I think the question about whether it's legal is still TBD. I've heard from press freedom advocates that this may be in violation of a 1980 statute called the Privacy Protection Act, which basically prevents use of search warrants for reporter work product. So whether or not this search actually was legal may be something that ultimately becomes contested.
So, Ben, we should kind of pull back a little bit, which is that it's unusual for someone who's not suspected of a crime. In this case, the reporter, if the Washington Post is not suspected of the crime, it's someone else. You might see that person's home seized, but not the reporter. So can you speak to how unusual this really is? Totally,
yes. This is very unusual. In 2013, as you probably remember, there was a big scandal over a Fox News reporter, James Rosen, with the Obama administration. And there was such an outcry over that it led to basically a policy with Eric Holder and Merrick Garland where they were not going to be aggressive with these searches as much anymore. And so Pam Bondi, the current attorney general, rolled that back in a memo. And so when this happened yesterday, a lot of people, press freedom advocates specifically, came out and said, why is this happening? This seems like a violation of protocol, basically.
So let's talk a little more about that earlier this year. I mean, look, we know the Trump administration is deeply hostile to the press, and every president complains about their media coverage. That's not new. But what is new are the personal attacks and things like this. As you said, the Attorney General rolling back some press protections earlier this year. So just take a step back and just speak to the chilling effect that this could have on just journalists, reporters who are trying to cover this administration, who are trying to do their jobs each and every day. There seems to be real fear this is, even if this reporter is not the actual target here, but it's still an intimidating measure.
Completely. And in fact, after this happened, I got a text message from a source who was basically worried about this very thing. It popped up on my phone moments after the story ran. And I think what's going on here is that sources are going to be now afraid to reach out to reporters because they're worried that the reporters' devices are going to get seized and they're going to be outed for disseminating confidential information.
So, David Rohde, what are you hearing about this story? What's the recourse for the Washington Post, the reporter, and, as Ben points out, reporters going forward here?
What's unusual is that, frankly, she's not a national security reporter. She doesn't have, like, classified information about military plans or something like that. She covers Trump administration cuts to the U.S. government. I'm just looking at her page here. One story, callers to Social Security wait for hours to get help. Hear their ordeals. Another story, NASA has lost thousands of workers. Here's what that means for science. I don't see how that endangers national security. And she's talked to workers across the federal government, and they didn't even didn't approach the Post and didn't approach her about possibly cooperating. They probably wouldn't have. But again, it's this super aggressive escalatory thing, and it's, you know, she's not involved in disclosing classified information or at least secrets that, as far as I can tell, based on her beat and her stories.
And the story this is centered on, though, she talks about people who are leaving the federal government or still in the federal government, giving her information. So talking about some of the tradecraft there, which may have flagged it for the federal government. The Department of Defense was involved here. I just think it can't be overstated. This is an escalation. This is something that press groups, media organizations, I know a lot of organizations had emergency briefings yesterday talking to their reporters as to how to handle something like this. So talk to us just a little bit, if you will, like how all of us and our colleagues navigate this going forward at a time where, like, First Amendment rights are being threatened.
Totally. I mean, I've had briefings with people at the Times talking to us about information security because this is so important. There's things that reporters can do using encrypted apps like Signal, not identifying sources by name in documents. There are a bunch of things that reporters can do to try to protect sources. Many news organizations have lawyers that can advocate for us in court. But the problem is that the press, as you know, is under increasing economic and political pressure. And not as many of these news organizations have the resources to fight back in court and the resources to protect their sources adequately.
Absolutely chilling. Behnam, just back to the legality issue, which you will be exploring, I know, extensively. What normally must happen before the search of a home, a reporter's home in this case? Doesn't a judge have to approve it? Doesn't it have to go through a process? And do we know that that happened?
Yes, that's a very good question. It's my understanding that under the Privacy Protection Act, if you want to use a search warrant to search a reporter's home for reporter work product, you have to demonstrate that the reporter committed a crime or has probable cause to have committed a crime with the material that they obtained. And Eric Holder in 2008, when he investigated James Rosen, I believe in a court document said that James Rosen had aided and abetted. And that caused a huge backlash because the DOJ never prosecuted him. So that's a very high bar to clear. And at this point, it's unclear whether the DOJ cleared that bar.
All right. We'll be following your reporting. Thank you so much for coming on this morning.